All right, guys. Okay, let's go through this filing from the New York Times. So this is in the Supreme Court of the state of New York, and this is obviously the lawsuit from the New York Times against Wayfarer, and they are basically seeking their attorney's fees and costs. It's a very, very short filing, actually, so this should not take long at all. Okay. Plaintiff, the New York Times, respectfully requests the court take judicial notice of the attached so-ordered notice of settlement and joint stipulation dated May 7th, 2026 from the U.S. District Court for the Southern District of New York in Lively v. Wayfarer and Wayfarer v. Lively. This action by the Times seeks its attorney's fees under the New York anti-SLAPP statute based on the dismissal of the libel and related claims brought against the Times in the consolidated action by Wayfarer and affiliated parties. On January 14, 2026, the Times filed a motion for summary judgment in this action. On February 27, 2026, defendant Wayfarer Studios opposed the motion and requested that the court stay this action. As a basis for the proposed stay, Wayfarer argued that it might later appeal the dismissal of the claims against the Times in the consolidated action. So the motion for summary judgment was entirely briefed, so there was nothing more to say. But then Wayfarer filed a motion for stay, and what they were basically saying is, oh, hold on a minute now, it's not necessarily the end. We do have a right of appeal, which was true. And what the New York Times have done is, and they couldn't run to the court fast enough to do it, is let the court know that as a result of the settlement, all, rights of appeal have been waived by Wayfarer in regards to their dismissed complaint. And we'll have a look at that as well, that part of the settlement stipulation. Okay. However, as part of the so-ordered stipulation, Wayfarer waived all rights to appeal any order in the consolidated action, including the order dismissing the claims against the Times. As a result, the asserted basis for the stay no longer applies. For this reason, in addition to the reasons set out in the Times reply, the Times respectfully requests that this court adjudicate its motion for summary judgment, which is fully briefed. Okay. So this is the notice of settlement and joint stipulation, and just this little part here. The stipulating parties hereby irrevocably waive any appeal of any orders in the consolidated action, including without limitation any appeal by the Wayfarer parties of the order on the motion to dismiss. So that is not just a right of appeal against Blake Lively. They've obviously settled with Blake Lively, but it is not just a right of appeal against Blake Lively that they have waived. It is against Ryan Reynolds, New York Times, and Leslie Sloan. So there will be no appeal whatsoever. So, it makes complete sense that obviously the New York Times have gone to the court and said, right, hold on a minute. They'd requested a stay on judgment, on the basis that they might appeal. The appeal is now off the table. Can we just now proceed to judgment? So we'll have to see what happens next. I don't think there's too much that Wayfarer can do to oppose it. They probably will respond to this, but there's not much they can say to oppose it because they have waived their right of appeal. And if I'm being really if I'm laying it out there, like my personal opinion is that I think that there's a good chance the New York Times will get their fees too. So it is not the same request that Lively's making with the 47.1, but I do think that the New York Times will get their fees under this under anti-SLAPP statute. So we'll see what happens next, though. Let me know what you think in the comments.